Right, hi, welcome back. This is Copyright 3, Part 1, and we're in the textbook at pages 162 to 170, and this week is admittedly a pretty big chunk. We'll try to make it as clear as possible, but you should definitely show up at the Q&A if there's stuff that you don't understand. So the general topic here is users' rights. So we looked previously, right, in the 2 previous weeks, we looked at what copyright is, how do you know if someone has a copyright in something. Then we looked at what are the rights of the copyright holder. So we looked at what the copyright holder is the only person that can do under the copyright regime, because as we said, the copyright regime, once you've proven that you have a work that is copyrightable, that you have a copyright in that work, that you own it, right? The Copyright Act says there is stuff that only you can do, and we kind of looked at the list of those rights. We looked at a couple more extensively. As we said, in the Copyright Act, there's actually a very extensive list, but we looked at the most important ones, right? And now we move to kind of a different standpoint, and we look at users' rights. And so we looked at what it is that someone who is not the copyright holder can do. And what I just said is pretty significant. Someone who is not the copyright holder. So we'll draw a distinction here between 2 types of people, right? We'll call them a user with a right, and perhaps a user without a right. And so what's important here is that the word we're using is user. It's not licensee, it's not person that was authorized, it's user. And so we're looking both at people who have authorization to do something, right? Someone who's purchased the right to, listen to a song, play a song, whatever it is. But we're also looking at someone who has no right. Someone who might, consult a book from a friend, for instance, without paying for it directly. So without compensating the copyright holder and without themselves having a right in the first place, right? And that's also true of examples that are very unrelated to what I just said. For instance, let's say a news station plays a portion of a clip of someone, to show people either what happened or to comment on it. Well, they don't own that, right? And if it's a substantial part of the clip they're playing, well, then they're infringing the rights of the copyright holder, because we always have this trigger issue of substantiality. So if they play a substantial portion thereof and it's a copyrightable work, then they've infringed the rights of the copyright holder. And obviously we have to have exceptions for these kinds of things. In that situation, right, the news station doesn't have anything. They don't have a right in the work. They're just users, but not authorized users, right? They haven't paid to do one thing with the news clip. They haven't paid anything, and they don't have a right in the first place to do anything with the news clip that they got directly from the copyright holder. But in some situations, they still have a right to do something with the work, right, under the Copyright Act. So the Copyright Act gives them a right, right? So that's kind of an important distinction, right? It's a right that's given to them not by the copyright holder, but by the Copyright Act, essentially, by virtue of the statute, not by consent of the copyright holder. But it is also, in that case, a right that is an exception, right, to this commercial monopoly that we discussed. And so by default, right, the copyright holder has the right to control stuff. And in the case of, say, the news station I just mentioned, well, it's pretty simple, right? The copyright holder has the exclusive right to play the work or a substantial part thereof. And so the news station is infringing on the right because they have this commercial monopoly. In other words, they're the only ones who have the right. They have an exclusive right to do something, in that case, play the news clip. The Copyright Act needs to make an exception to that, right? Because by default, the copyright holder has this monopoly on the exercise of the right. Has the monopoly on the rights we listed under the rights of the copyright holder, which we looked at previously. This is also different from other areas of the law, right? In other areas of the law, you only have the rights that are given to you by statute. That's not the case here, right? By default, we kind of give everything to the copyright holder, and so we have to carve out specific exceptions. So the default, right, unlike a lot of other areas of the law, is not that you have no rights as a copyright holder. It's that you have all the rights. And so if we want to make exceptions for what people who are not the copyright holder can do, well, then we have to list these exceptions explicitly in the Copyright Act. And as we'll see, that's what we do. But remember here that we're talking about both of these kinds of people. Someone who has no right, who purchased no right or has been given no right by the copyright holder. Also someone who has a right, so someone who purchased or who was given the right to do something, but then either does something else, which they're not authorized to do, and they have to be, right? Or someone who does what they're supposed to do, but in a way that is different and that engages another one of the rights of the copyright holder, and therefore we need to make an exception, right? So, in the first place, right, the book looks at it from the perspective of litigation, which is kind of an interesting way to look at it, right? So in the first place, what is someone going to have to prove, right? Let's say I go to court and I say, well, someone has infringed upon my copyright. So what do I have to show before we get into users' right? Well, I have to show that I have a copyright. So I'll have to show that I have, we'll formulate it. These are not really three different things, but we'll formulate them this way because it is simpler. So the basic things are going to be, right, that I have a right, that it is not expired, and that I own it, right? And what's important here is to remember that that is a consequence of the registration regime that we looked at in previous weeks. So all these things are interrelated, right? So I said in previous week that registration is not a condition of existence of a right. We'll see in other areas of law next week that that's not always the case, right? In some situations, for you to have a right, you have to register it. And so you have to hire a lawyer, you have to file the paperwork, then the government evaluates it, and then they put it in a registry. And you have your right, typically, pending, an exception that might apply, you have your right from the moment that it's registered, from the moment that it's entered into the registry. As we said, there is a registry of copyrights in Canada, but it is not mandatory. And so to have a copyright in Canada, you don't have to register it, right? So what does that mean? Well, first, the existence of the right kind of begins whenever the statutory conditions are met. So as we said, how do we know what a copyright is if it's not registered? Well, we know because the statute, in that case the Copyright Act, says, well, that's why you have a copyright. And so the moment the right starts to exist is the moment that under the statute you've met the various conditions, right? Originality, fixation, so forth, right? We looked at them. The two main ones are, original enough and fixated onto a physical medium, right? And you have the right from that moment. And so registration is not relevant. So even if afterwards I go out and register it in the copyright registry, right, that doesn't change the fact that my right began to exist from the time I met the statutory conditions, because registration is not mandatory, and because registration does not affect, by virtue of the fact that it is not mandatory, does not affect the validity of my right, even if it's registered, right? So in that case, I go out and register it. That doesn't change the fact that I've had the right much before. So I can still say, well, before I registered it, you still infringed it. That's possible. Unlike other areas of law, where often registration is a condition of existence and therefore your right is only valid from the time it's registered, right? So, as a consequence of that, right, if I go to court and I say someone has infringed my copyright, there is not a simple way to know if I have a copyright in the first place, right? Sounds kind of simple, but it's pretty important. So if I'm saying someone's infringed my copyright, what am I saying? I have a copyright and someone has violated my rights. These are two separate things. And there isn't a registry, right, that says I have a copyright because the government said so. That would be simpler, right? In that case, we could just produce the registry and that would be it, right? That's not the case. Or it's the case if I voluntarily registered my right, but it's not necessarily the case, and in most cases, it won't be, right? So, usually, in a copyright action, in a copyright lawsuit, the first thing that the plaintiff, in that case, the person that's claiming copyright infringement, is going to have to do is show that they have a right. And so they'll have to show that they've met the statutory conditions that we've looked at before, originality, fixation, and so forth. And so first, they're going to have to show that. Second, right, they're going to show that the right has not expired. That's not really a different thing, right? But it's helpful to think of them as you know, to enunciate them as three separate things, but they're not really three separate things, because if my right's expired, well then it's no longer valid. And so even though I have a right, I can no longer, you know, use it because the stuff is reverted into the public domain. So I have to show that I have a right. I have to show that it's not expired, right? And I have to show that I own it. Again, it's not really different, but it's helpful to think of it that way, because as we said, as a copyright holder, I can do whatever I want with my rights. I can give them to someone else in whole, in part, for money, for no money, whatever. And so I have to show that I still own the right, because even though I might have a valid copyright in my book, if I've sold the right to sell my book to some company, well then I no longer own it, right? And so I cannot bring the action, because I cannot say that someone's infringed my copyright, even though I have a right. Well, if it's expired, right, then, you know, my right is no longer assertable against a third party. And so I cannot sue for copyright infringement because my copyright's expired. In the same way, well, if I assign my copyright, I no longer own it. And therefore, even though I have a right, I cannot assert it against third parties because I no longer own it. You can't assert a right that you don't own, right? The person you assigned it to can. The person you sold it to can, but you can't. So in copyright action, we'll have to prove that. That's a consequence of the fact that the registration regime is optional. The second thing we're going to have to prove is, you know, unsurprisingly, infringement. As we said, you know, if I go to court and I say you've infringed upon my copyright, I'm saying I have a copyright and you violated it. So, in the textbook, you're told that the defendant has the onus, right, to negate the right of the copyright holder. I think that's awfully weird and confusing, and I don't agree with that. So, we're introduced to what's called a defense, right? And what's a defense? Well, it depends on how you define the defense. So, the way law students are typically taught defenses is generally wrong. It's given a definition that is wrong to make things simpler for either lawyers or law students, but it's not actually correct. So we'll think of it, you know, conceptually. If we take a step back, what's a defense? A defense is, right, I agree that you have a right. I agree that I did something wrong, but I have a good reason for it. And so let's call this an excuse, right? And so I'm saying, well, you know, you have a right, or whatever you're saying happened, but there's an exception that says that you cannot sue me, right? And so conceptually, right, what happens? Well, first in a defense, right, there's going to be a right that's going to be infringed upon, right, first, and then second, there's going to be an excuse. And so conceptually, right, the defense happens here. The defense happens after I've recognized that I've done something wrong or that I've infringed upon your rights. But I'm saying, yeah, but I've got a good excuse for having done that. That's a defense. In our case of copyright infringement, so we're still in that theoretical lawsuit where the plaintiff, right, is the person that says their copyright has been infringed. And so the plaintiff goes to court and says, defendant, the other person, is infringed upon my copyright. And so I want to get generally money from them. Well, in that case, as we said, we have to prove that I have a right and that it's been infringed. And the defendant, in that case, generally speaking, is going to do one of two things, right? They're going to negate, typically, the two things that are part of the thing I'm suing for. As we said, I'm suing for copyright infringement. Copyright plus infringement. Well, what is the defendant going to do in that theoretical case? Well, typically, right, they're going to attack both parts of the syllogism. They're going to say, well, you don't have a copyright in the first place. And so I'll show that your copyright is not valid, that your copyright, is not original enough, is not fixated, is not something that is typically copyrightable. Or I'll say, well, you do have a right, but I haven't infringed upon it. These are the two things you can negate, and you only need one of those to be true, right, as the defendant, right, for the plaintiff not to win. Because copyright infringement requires copyright and infringement. And so if you're successful in showing either that there's no copyright or that there's a good reason for the copyright infringement, then you're good and the lawsuit is going to be dismissed, right? Well, the book says these two things are defenses, and they're not. These two things are defenses broadly construed, right, wrongly construed, because there are things that the defendant is going to do, right? And so typically the defendant does these two things I've just mentioned, and so some people call these things defenses, but they're not, because the first thing that I'm saying the defendant does, which is to say you don't have a copyright, well, from this taxonomy we just discussed, that is not a defense. It's saying you don't have a right. It's not saying I've got a good excuse. It's saying you don't have a right. And so conceptually it doesn't operate at the same level, right? The defense is here. The defense is the excuse, right? Whereas the first thing I've just mentioned is this negating that you have a right. It's not saying that I have a good excuse. It's saying that I don't need an excuse because I haven't done anything wrong. And so even though the book calls these things defenses, the only thing that's a defense is saying, yes, you do have a right. So the first part of the analysis that we said, right, copyright plus infringement, has been shown, right? And then, right, we're trying to say, well, once you've established that you have a right as the plaintiff, I have a good excuse, right? The Copyright Act says that what I did is okay. And so that's a defense. Now, in the book, you're told that the main user's right is what they call the fair dealing exception. So we're looking at, again, the sections called users' rights and defenses. Most of them occur at this second step, right? So we're saying even though what I did was an infringing action, even though I've infringed upon the rights of the copyright holder, there's an excuse. And where's the excuse? Well, by virtue of my commercial monopoly, it has to be in the Copyright Act. The main one is what we call fair dealing. What's fair dealing? Well, it's this fancy legal word. It doesn't say much, but fair dealing is essentially using your stuff for a good reason. And the reason it's the main defense is because it's also the broadest one. And that's going to cover a lot of things. If I'm doing academic research and I'm using something that's fair use, if I'm taking parts of your book to say it's junk, right, or to say it's good, well, in that case, what I'm doing is also, asserting the fair game exception. Because what I'm saying is, I have a good reason. I'm using your stuff, but I'm infringing upon your copyright to provide a commentary. And when we get back to this idea, right, we want to limit as little as possible, right, people doing things, right, that A, don't really infringe upon the commercial monopoly upon the use of the right that we want the copyright holder to have, and B, that are kind of important aspects of the human experience, right, that allow people to come up with their own stuff, to use stuff, right, and to produce their own work, to use them in educational institutions, to put them on the news, whatever it is, right? And all that is going to fall under the fair dealing exception, which we're going to look at in greater detail in a separate section. But again, it's important to think about in the first place that these things are justified under the copyright regime because they don't really jeopardize what the copyright regime is there for. As we said, right, most of the copyright regime is concerned with economic and not moral rights. And what does that mean? Well, it means that the main thing we're trying to protect is the ability of someone producing something to make money with it, right? For someone not to come in, take it, make money with it, and in that way, you kind of lose, right? Because you don't sell it yourself, someone else makes money with it, right? And so, in these defenses, what people are going to say is essentially that even though they've infringed upon the copyright, that what they're doing was basically allowed. And again, to go back to my example of the news that I've just given you, well, in that case, right, as a copyright holder, the person who owns a news clip, right, you could technically prevent everyone from using it. And that would be bad because no one could report on stuff, right? If you're the only one that's filmed something, right, that should be on the news, something that should be reported, well, you're still the copyright holder. You still own your clip, right? And technically, you can prevent the news stations from using it, right? Because you can use your rights however you want. And so you can say, well, either I don't want news stations to use it, or you can say I'm going to charge an enormous amount of money that essentially is going to do the same thing, that news stations are not going to be able to use it. The fair dealing exception is the main one. There's a bunch of other ones, right? You're given, for instance, what's called the means of telecommunication exception, what we also call the common carrier exception, right? Which is this exception for people who are just intermediaries, right? We looked at that previously. We said, if someone's posting something on Facebook, well, Facebook doesn't really help you infringe copyright, right? Facebook just provides a place, like a park is a place. And Facebook doesn't contribute to the copyright infringement, and so Facebook should not be held liable. And that's also true of other contexts that are not technological, for instance, in telecommunications, and that's called the common carrier exception, essentially because before we had technology, they were carriers. And there's a bunch of other exceptions you're given in the Act. There's exceptions for the National Archives of Canada. There's exceptions for persons with disability. There's all sorts of exceptions, right? And then you have Section 32.2, which is mentioned briefly, which is just like this very long list of things that they could include elsewhere. So they made these sections for things, right, that have their own, justification, right? Like, for instance, as I said, the common carrier exception has its section of the Copyright Act. Well, there was a bunch of things that were just, incidental that they couldn't include elsewhere, and so they put Section 32.2, and they just put this big list of stuff that says even though it's copyright infringement, it's not. For instance, taking a picture of a building, that's included under the list. But the only ones that you have to learn are the ones that we're going to look at, mainly, fair dealing, the common carrier exception, and a bunch of other smaller ones that we're also going to look at. So, you're also told about the 2012 amendments, which included things that were basically already in the case law, right? So the main exception is they've expanded the fair dealing exception for education, satire, and parody, right? So again, fair dealing exception is, I'm using something to comment upon it or to do something else with it, to do research, to report on the news, to, whatever it is. Well, they added satire and parody. So you can take a clip of something, even though it's copyright infringement, to make fun of it, and an education exception. They've also added this private copying, which you were already allowed to do under a bunch of other cases, but which they clarified, right? They put it in the case law so that it would apply to everything. Basically, when you've bought a right, essentially you can make private copies for non-commercial use. And so you can, take the song back when it was on a CD, you can make a copy of the CD, and that's fine as long as it's for your own private and non-commercial use. And so private use, and you don't make money with it, right? And they added a bunch of other exceptions that we don't really look at. They're called circumvention rules that were added because of a trade deal that Canada signed, and that kind of helped to prevent internet intermediaries from going rogue, from the fact, right, that now there's greater access to things on the internet, basically. But as I said, we're not going to look at these things. The other exceptions, we said fair dealing, we said the exception, the common carrier exception for telecommunications. Another big one that we're going to look at is educational institutions, right? And so for both libraries and educational institutions, there's separate rules, right, that give separate exceptions to these people to violate other people's copyright, basically. And oftentimes, as we'll see, you can fall under various exceptions. And so we looked at the case of the Law Society of Upper Canada, right? And the Law Society of Upper Canada could assert, more than one exception. So a defense, they could say, yes, I've infringed upon your copyright, but I have a good reason for that. So you'll remember, right, the Law Society of Upper Canada of Ontario had this, system where they had photocopying machines, and they could also make photocopies for you. And they put the sign on the photocopying machine that says, well, if you do something wrong with our photocopying machine, we ain't responsible. And so, we don't want people to violate copyright. And then they got sued, and the person said, you're contributing to copyright infringement for a bunch of reasons we discussed. I'm not going to go over them again. And the court said, well, no, the sign's there because you don't want people to commit copyright infringement. Well, the Law Society of Upper Canada can claim the common carrier exception, right? They can say, well, we just kind of put the photocopying machine there, right, for everyone to use. And so we didn't contribute. We just provided it, indiscriminately to everyone that comes into our library. And that's fine. That's allowed under the common carrier exception. And even though someone infringes copyright, you're not responsible. The person who uses the machine is, but as the library, in that case, you're not. Well, the library can also assert the defense of educational institutions. Typically, they do both, and typically they do the education exception last because it has these, more arcane rules that are both, kind of old and that are, that are more tedious to respect. But in that case, right, the Law Society of Upper Canada could have fallen under the two exceptions, right? So, as I said before, from this distinction of economic and moral rights, right? So I said that you have to own your right, that you have a right to, assign your copyright, to give it to someone in whole or in part, for free or not, whatever it is, right? But we also said that there are moral rights. So we said most of the copyright regime is concerned with economic rights. But it's not true that there's no protection for moral rights. It's just that the protection is much more limited. it's under a different section, a different regime, right? And it's also, it's also defined differently in what you can do with your right. Because by default, with your economic rights, you can do whatever you want with it. You can assign them to someone, you can sell them permanently, whatever it is. That's not true of your moral rights under Section 29. So your moral rights, you can only waive them. And what does that mean? It essentially means that you can authorize the infringement of your moral rights. So basically, my right to the integrity of my work, you'll recall that I gave you the example of my statue. If someone puts toilet paper on my statue, well, in that case, I can go under Section 29, which is where my moral right is protected. And what can I say? I can say, you've infringed upon my right. And as we said, that's a separate regime that has an additional requirement, and that requirement is to the prejudice or honor of the person that is the copyright holder. And so I'll have to show not just that you've breached the right to integrity of my work, but also that you've done that to the prejudice of my honor or reputation. And what does the regime say? The regime says that this right can be waived. So what does that mean? Well, I can give you authorization. And so even though, right, putting toilet paper on the statue would normally be, breaching my right to integrity, to my prejudice, to the prejudice of my honor or reputation, well, I can authorize you to do that. And so I waive my right. I essentially give you authorization to breach my right. Whether you call it consent, authorization, waiving, it doesn't matter, right? What I'm waiving is not really my right, even though it's phrased that way. So I'm not saying I'm getting rid of my moral right to integrity. It's just saying that I'm waiving my ability to object to your specific use of my right. And so I'm saying I'm waiving the objection. So I'm waiving my right to sue you for breaching my right to the integrity of my work. And thereby, I'm essentially letting you, infringe upon that right. And there's something that's mentioned very briefly that's also kind of interesting that we have to think about more broadly, right, is this idea of how technological mediums can change existing rules. So you'll recall the private copying exception. So as I said, there's a bunch of exceptions, a bunch of defenses, a bunch of excuses that you can use when someone's saying that you've infringed upon their copyright. And you can say, yeah, that's true, but I have a good reason. We'll look at three main ones in this module, but, one of the other ones that we're not going to look at is a private copying exception, which you'll recall, if I buy a CD, I can make copies of it. Well, in that case, we have to be careful because the rules were made at a time where, you'd actually buy a CD. And in that case, it's not really complicated because you're buying a thing that has the song on it. And so it's clear that the medium is the CD. And it's clear that if I, put it onto my computer, put it onto another CD, right, another physical thing, that I've made a copy of it. And if that copy is private and for non-commercial use, I'm good. Well, that's not always going to be the case with technology, right? If we buy a song online, we have to be careful before applying these exceptions because these exceptions for private copying, but often, right, I might not even have the right that allows me to do private copying. That's just an example. You don't have to remember it, but it's an example of how technology kind of, changes the case law and how we always have to think of how, the broader principles apply in a context of technology in a context where, frankly, the rules weren't made for. So if I buy a song online, well, technically, if I do it the old way, if I can download it, well, then I can make a copy of it. It's private copying for non-commercial use. I'm good. But oftentimes, right, the company might change the nature of my right, and the exception might not apply, right? So even though it looks like the song I'm buying from iTunes is me, buying a song, downloading it, the same way it would be me, downloading it online or buying a CD. It's not. It's a license, right? And what's a license? Well, it's a copyright holder saying you have these limited rights. So the copyright holder might well have said in that specific instance, well, you only have the right to listen to it, not to make a copy of it. And then these defenses are not going to apply because I don't have the right that allows me, to claim these defenses. I have a more limited right. Or, right, I have a right, but that the company says is subject to me not using these defenses. And that is permitted under the copyright regime. The company, right, can take away my defenses. The same way it can bargain away its right, its copyright, I can also bargain away my defenses. And so the company might have said, well, you're waiving your right to the private copying exception or whatever other exception it is, and that's allowed. So we always have to be careful in analyzing both the nature of the right that was given first and then what defenses arise as a result of that. As a general rule, it's going to be all of them, but you have to either have been granted a right or have done a use that is covered. So that was a long introduction. In this section, we have two other exceptions that are covered briefly before we get into the three main ones. So one is the public interest exception, right? And the other one is the freedom of expression exception. And they're both covered by cases. So the public interest exception is essentially, well, I've done something that's in the public interest, right? So basically, my infringing action is in the public interest. It's not really defined more specifically than that. And you have this case, the James Lorimer and Company case, right, which is this guy who takes a government report, then copies it, right? He does some editing. It's a very long report, right? He kind of condenses it down and starts selling it. And then what does he say? Well, he says, my infringing action is allowed because it's in the public interest. And so obviously, copying most of the government's report is copyright infringement because the government can have a copyright, as we said, right? The government, the Crown has copyright. There's separate rules, as we said. There's a different, period that's calculated for how long the right exists for. But the Crown's allowed to have, copyright and therefore, claim copyright infringement. Well, if the guy takes the report and takes most of it, that's infringement of the copyright because the work is copyrightable and he took a substantial part thereof, right? And on top of that, right, what he does is he makes money with it. And so what the court says is basically, the extent of the disclosure was important, right? And so he took, a big chunk of it and he disseminated it widely. And what does that mean? It means that it really, jeopardizes this monopoly of the copyright holder, right? So he doesn't just kind of distribute it, right, to people who wouldn't have bought it anyway. He starts selling it to people who would have probably, got it from the Crown, from the government, and therefore, he jeopardizes this commercial monopoly. And I'm going to propose something here. I might be wrong. That's my opinion, right? I'm going to tell you the court doesn't say that, but I think we'll see that as a conducting thread in the various, defenses we're going to look at. An important way, right, an important characteristic is that it jeopardizes the monopoly of the copyright holder, as I said, and a good way to see that is if you've made money with it. And so my hypothesis, I might be wrong, you might write a paper as to why I'm wrong for your final paper, but my hypothesis is that, making money is a good indication that you have jeopardized the economic rights of the copyright holder. And so in that case, the court says, well, you copied it, you didn't attribute it, and you made money with it. I think the main, the main suggestion there that the public interest exception or any other defense would not apply is that you've made money with it. And the defenses, as a general rule, don't exist for that reason. They exist to protect other uses, right? So they exist for you to cover stuff on the news. They exist for you to conduct your research. They exist for you to, have your wife listen to the song that you've bought. They don't exist for you to start selling stuff and doing what the copyright holder would do. And in that case, I would suggest that the indication, like the thing that made the court decide the way it did, was the fact that he made money with the report. So not only did he take it and disseminate it to people, which is in the public interest, right? It's a government report on, I don't recall, it's on the state of competition in the Canadian petroleum industry. So presumably, right, the government took your tax money and made that report because they thought it was in the public interest to, have information on that. And the guy could have said, well, I've shared it with people, and that's effectively, a permutation of what he said. He said, well, I've shared this with people because I wanted them to know that there's no competition in the Canadian petroleum industry. Well, that would have been applicable, but you made money with it. And so your exception doesn't make sense. Your defense, is kind of hard to raise because really it seems that what you were doing is trying to make money with this stuff instead of the copyright holder. Second exception that's also addressed briefly is the freedom of expression exception, right? And obviously, right, freedom of expression is protected by the Canadian Constitution under Section 2, right? Section 2 says your freedom of expression is protected. And so, in a case, right, you can go to court and say, this infringes upon my constitutional right. Because, in this kind of hierarchy of rights, the Constitution is on top, right? So your constitutional rights trump everything when the Constitution applies. There's a situation where the Constitution doesn't apply, right? Like a private company in a lot of situations. But where the Constitution does apply, the Constitution trumps everything else. Everything has to respect your constitutional right. And so, what does that mean? Well, I can do two things, right? I can either say, well, the whole Copyright Act infringes upon my constitutional rights. And so, this section of the Copyright Act is invalid because it restricts my freedom of expression too much, right? There's various tests as to how much your various rights are protected, but I can say that. Or I can say, well, it is true that I've infringed upon the rights of the copyright holder, but that's justified because otherwise, you'd be preventing me from having my freedom of expression. That's also allowed. And so you have this case, right, the Michelin case, where essentially you have this union that wants to produce flyers, and what do? Well, they take stuff that is copyrighted. So they take the Michelin Man and then they put it on their flyer and then they start distributing it. What this Michelin says, right? Obviously, company wants to have good reputation, goes to court, sues its union, right? And the company says, well, you've infringed upon our copyright. And what does the union respond? The union responds, yeah, we did, because, they did copy the Michelin Man, but we have a good reason. That's freedom of expression, right? You'd be preventing us from, expressing our freedom of expression, right, by passing out flyers, right? Your right to unionize in some situations also protected under, the same section, but not, the same subsection. So you have Section 2, which protects, your right to freedom of expression, but also association. In that case, what they were claiming is not that the fact of unionizing, was prevented by the copyright action, but rather that the right to, express themselves, to pass out the flyers, to, tell the employees that Michelin was a bad company was infringed by Michelin exercising its copyright. So again, conceptually, right, we're still in that taxonomy, right, where you have to have your right and you have to have infringement. Well, they said, yes, it's true that we used your copyright. So you have a right, you have a valid copyright, we infringed it, but we have a good excuse, right? The good excuse is we have to have freedom of expression. And what does the court says? Well, the court says no. Essentially, right, conceptually, because it doesn't infringe upon their freedom of expression that much. Because there are other ways, right, to pass out flyers, to have your union organized, to convince people that you're right, that don't involve you copying the Michelin Man on your stuff. So the court says, well, you know, if that was indeed the only way for you to express yourself, it might be illegal, but it's not, and so it's not illegal, right? And so, you know, in that case, right, Michelin exercising its copyright, Michelin saying you've infringed upon our copyright is not in contravention of the Constitution, of your right to freedom of expression. And what else does the court says, right? The court says, because the court's really mad there, right? The court says two things, right? It says you lose under both Section 2 and Section 1 of the Constitution. So if we back up a little bit, right, how do constitutional rights work? Well, you have this list, right, and the courts interprets them, right? So the list might say, well, you have a right to freedom of expression. And what does that mean? Well, it's not clear. And so eventually the court is going to have to apply this. And the court's going to say, well, it means that, you know, you have to show these two things, and then someone else can say, well, it's justified because these other two things. And so the court has this test that it elaborates to evaluate whether your rights have been infringed. And as we said, the court says, under the relevant test, which is not relevant, you don't have to learn it, under the relevant test for freedom of expression, your rights have not been infringed, or have not been infringed, you know, enough for that to be illegal. And the court also says that it is allowed under Section 1 of the Constitution. And what is Section 1? Section 1 is basically a broader exception. And so you have sections that have their own limits in them, right? So Section 7 is your right to life, liberty, and security, right? Well, your right to life, liberty, so forth, says you can only be deprived of that within the limits of what's allowed in a democratic society. These are not the exact words, but that's essentially what it says. Well, then you have a limit on the right. So Section 7, right, for you to claim that someone's infringed your Section 7 right, you have to show both your right and that the limit to it, that it can be limited within a democratic society, doesn't apply. So that they've limited your right not in accordance to what we have in a democratic society. So some rights in the Constitution have, you know, their own internal limits. Some rights don't. Regardless of whether they do or don't, right, you have Section 1. And what does Section 1 say, right? Section 1 says that you can have some further limits that are prescribed by law and demonstrably justified. And so for all of your constitutional rights, the government's allowed to take them away, or whoever it is, right, is allowed to take them away as long as it's not too much. And so the judges say, well, you know, we didn't violate your Section 2 rights. We didn't violate your right to freedom of expression. But even if I'm wrong on this, right, the violation would have been justified under Section 1. And Section 1 says, right, some of the violations can be justified as long as they're justifiable in a free and democratic society, right? And so the court applies this test, which again you don't have to learn, which is basically about proportionality, right? So under the Oakes test, that's what we call it, the Section 1 test, which was elaborated in a case titled Oakes, you have to show, you know, a connection between the law's objective and the way it meets that objective, right? Then you have to show minimal impairment of the charter right, and then you have to show proportionality, right? So you have to show that the objective of the law kind of justifies, you know, what you're doing, which is infringing upon someone's constitutional rights. And what does the court say? Well, the courts look at the entire copyright regime and says, yes, the Copyright Act is a limit to your freedom of a lot of things, including expression, right? It's a limit on your right to access stuff, to say stuff, to write, Facebook posts that reproduce someone else's work if it's copyrighted. It's a limit to your freedom of expression, but the court says, regardless, it's clear that the Copyright Act is a reasonable limit, right? It's clear that the Copyright Act is a limit that's justifiable in a free and democratic society. It would be hard as well, because of how the Copyright Act was described in that case, to claim later on that the Copyright Act generally or more broadly infringes upon constitutional rights in an unjustifiable way. So in specific situations, you might show that applying the Copyright Act violates your constitutional rights. But in most cases, if you're trying to say something broader than that, then the court would probably look at what was said in the Michelin case.